Good morning. Happy Friday. A long time ago, in a galaxy far, far away, I interviewed a police officer who went by the YouTube name Law and Smoke. Law and Smoke was going around on the various auditard channels. Brian King especially loved him because Law and Smoke was dumb. Excuse me, Law and Smoke was not very educated in the law. He was a cop. He thought like a cop. He acted like a cop. But he was no longer a cop because he was, a touchy feely California guy now. And, can't we all just get along? And so they loved him. They paraded him around. He was the latest in the long string of cops that were supporting auditards. First, you had Damon Jones, who, no more needs to be said. The guy's a crook and a shyster, and he is thoroughly disgraced in the law enforcement community. Then you have GED Jack, Texas Sheepdog 72, another disgraced former officer. Law and Smoke, to the best of my knowledge, wasn't disgraced. He worked on the force, I think, for about 6 or 8 years in Arizona, and then he left that because he didn't enjoy being a cop, and he decided to teach, I think, criminal justice. Or something along those lines. But I got him onto my Discord, and I interviewed him, and I discussed with him Terry v. Ohio. I laid out the fact pattern of Terry v. Ohio to see if he recognized it, mainly to see if he recognized it, because Terry v. Ohio is the quintessential case on when you can stop and frisk somebody. That is the starting point. If you don't know that, the subsequent cases won't really make sense. And he didn't understand it. He didn't know it. When push came to shove, because he was a cop, he had a basic understanding of stop and frisk. He understood that if he saw somebody standing on a street corner with bottle caps all around them on the ground, scattered all around them, he understood that they were probably dealing drugs, because in his time in Arizona, people selling drugs would put the little crack rocks into bottle caps. It might have been meth rocks, I don't know, but whatever. They'd put the drugs into the bottle caps. They'd fold them over, and they'd toss it on the ground, mixed in with a bunch of other bottle caps. So if the cops came, it didn't look like they had any drugs on them. But if somebody wanted to buy a drug, they knew which bottle cap to pick up. They'd pick up that bottle cap and get the crack rock out and sell the crack rock and make their money, and everybody would be having a good old time. And that kind of illustrates the difference in the way cops are trained versus the way lawyers are trained. Lawyers are very much book trained. We look at the law, we analyze the law. Police are more hands-on, and they deal with a very specific subset of laws. In order to be a lawyer, at least in California and in every state that I'm aware of, you have to be educated and skilled in all areas of the law. You have to, most areas of the law, the basic areas: property, torts, contracts, etc. Whereas to be a cop, you have to know criminal law. Specifically, you have to know the penal codes for your city, for your state. Unless you go into federal law enforcement, you have to know the federal criminal codes. But it's a very narrow field, and it's not as in depth. You don't do research on it. You crack open your little police manual, and you look up the statute to know what thing to charge someone under. You might Google search through your little statute. There might be, I've never looked at a police computer, but they probably have like little guides in there. Like if somebody's doing something like this, then it's this, I'm guessing. Which goes to show that I am not trained at all to be a cop, and I can't tell a cop if a cop's doing right or wrong unless it breaks into the field. Like, I can't tell you if a cop's really doing right or wrong policy-wise, or if he's doing right or wrong in his investigation, unless it breaks into a field of law, in which case I would be able to at least opine intelligently on whether or not the cop violated someone's Fourth Amendment rights, or whether or not it appears that there was probable cause, etc. So cops know things that I don't know, but I know things that cops don't know. generally speaking, hashtag not all. I'm sure that there is a cross section of cops who've become attorneys and attorneys who've become cops, and that's great. So anyway, 2 days ago, on my Greg Anderson round 2 video, Blue Bacon left, and I've written it down so I don't screw it up. He left this comment. He said, "I found Jacobson versus Massachusetts to be a good reference for how the courts might rule on the constitutionality of the stay-at-home statute. I recommend reviewing it." Now, as an attorney, that says a lot of things to me. That says he's actually he's read Jacobson versus Massachusetts, and he should be able to formulate an argument as to why it is going to be a good reference for how the courts might rule on the constitutionality of the stay-at-home order. Now, I did not review Jacobson versus Massachusetts in preparation for my video yesterday. But I know Jacobson versus Massachusetts. It is a vaccine case where he had all the due process rights getting up to and through the courts of Massachusetts all the way to the Supreme Court. So that's one thing I knew. Another thing that I knew is that it dealt with vaccines, not quarantines, not stay-at-home orders. And the third thing I knew was that it dealt primarily, the argument that Jacobson was making was that the preamble to the Constitution guaranteeing your rights to life, liberty, and the pursuit of happiness was law, which I've heard various arguments for. And in fact, there is a clip of me yelling at Maddie, Constitutional Corner, to cite where in the Constitution, not the preamble, because there's a fucking difference, but where in the Constitution does it say liberty? And I don't remember what his name was. I call him Bob. Midwest Media or something like that. It's on his channel if you want to hear me screaming incoherently at Maddie. Anyway, so I'm familiar with Jacobson versus Massachusetts, and it does not apply. And it does not apply any more than most other things apply. Now, he then on yesterday's video, he lists 6 opinion pieces out of newspapers. Now, a lawyer doesn't list opinion pieces out of newspapers. We don't research off opinion pieces out of newspapers. We don't rely on opinion pieces out of newspapers to make our arguments. And in fact, we actually make arguments. You might notice that I don't just throw up opinion pieces on my channel and say this is the law. I actually explain to you the thought process behind it, or at least I try to, and I make an argument as to why I think that is the case. So I made an argument in my video that it was a due process issue. That's why your remedy is a writ of habeas corpus. That gets you in front of a judge. That gets the due process rolling. I also had discussed In re Martin, Ex parte Martin, or I forget exactly what it's called, a California case that dealt with quarantine. And in that California case, it dealt with quarantine. It dealt with it based on due process. And it stated that you had to have essentially probable cause that somebody was infected and that they were infectious in order to quarantine them. So that is the reason why I thought it was going to be a due process concern. But now he's saying the experts disagree with me. He calls them experts. They're mostly reporters or opinion writers. And he says one of them is the dean and professor of law at UC Berkeley Law School. Wow. He says, doesn't that make you feel awkward, or isn't that awkward? And no, it's actually not, because first of all, like I said, I don't care about opinion pieces. Second, did you read the fucking opinion pieces? You have to remember, I want to remind everybody that his assertion was that Jacobson versus Massachusetts was a good reference for how the courts might rule on the constitutionality of the stay-at-home orders. Reference for how the courts might rule. So first thing you have to do is you have to issue spot as to what the issues are in the stay-at-home orders. You have to determine what the what form of attack is going to be made against it. And then you have to figure out what cases are going to be relevant to that form of attack. Now, I haven't looked up to see what cases I think are going to be the most relevant for the due process portion of it. I still think it's going to be something along the lines of ex parte endo, which had nothing to do with quarantine, but it does have to do with habeas corpus, a mass incarceration or internment. And because of the lack of probable cause by the government, that quarantine or that internment ending, i.e. the internment of the Japanese, that's my analogy. That's what I'm going with. I also listed a couple other cases, the Compagnie Française versus the Board of Health of Louisiana and Ogden v. Gibbons v. Ogden, something like that. So I listed those two cases as well. Gibbons v. Ogden stands for the proposition that the states have the right to make the quarantine laws, and unless there is a specific section of the Constitution or federal law that counters it, then the states get to do what they're going to do, and the federal government doesn't have the general power to regulate quarantines. That's not one of the enumerated powers of the Congress. Typically they're going to get there via the Commerce Clause, which I don't think is necessarily going to hit home on the stay-at-home orders. And Compagnie Française dealt with quarantines, and it dealt with healthy people. In Compagnie Française, they kept a ship full of healthy people out of Louisiana. They prevented a ship full of healthy people from docking at, I don't remember if it was Baton Rouge or New Orleans, but they kept a shipload of healthy people. And so it dealt with healthy people and quarantine. So I thought that it also dealt with Commerce Clause, treaties, and various other things. And I think that might be a little more on point than Jacobson versus Massachusetts. Well, looking at the 6 opinion pieces that he provided, 2 of the opinion pieces dealt with a Fifth Circuit Court of Appeals decision out of Texas. Now, I haven't read that Fifth Circuit Court of Appeals decision out of Texas yet, but it dealt with abortion. It dealt with whether or not getting an abortion was an essential service in Texas during the pandemic shutdown, which is not dealing with the stay-at-home order. And the articles reference Jacobson versus Massachusetts because the court stated a line from Jacobson versus Massachusetts that I don't have memorized, but it's essentially that your liberties can be subject to reasonable restraints for the common good, which is an entirely non-novel idea. The fact that they cited to a case for that proposition doesn't surprise me, but you have to look at the First Amendment. You've got the freedom of liberty. There's the Lemon test. Is the government express, or do they have a secular purpose for what they're doing? That's, I think, part 1. Part 2 is, if I remember correctly, does it have the effect of advancing or hindering religion? And the third part is, does it cause excessive government entanglement in it? But if you look at the language of those, excessive government entanglement, there is a reasonableness aspect to it. The second part of the First Amendment, the freedom of speech, you've got the various scrutiny tests, strict scrutiny, what do they call that? Reasonableness, the reasonableness test, and intermediate scrutiny, the reasonable time, place, and manner. Reasonable is in there. You've got the same scrutinies, intermediate, strict scrutiny, and I don't know why I'm blanking on the lowest level one, rational basis review. They all deal with reasonableness. Those are the tools that the courts use, generally speaking, to determine whether a law is constitutional. Reasonableness is in there already. So this is an entirely unremarkable proposition, and it didn't deal with the stay-at-home orders. The other 4, including the one by the professor of law, dealt with, generally speaking, the regulations that are being put into place. The orders, generally speaking, may be constitutional because of that language in Jacobson versus Massachusetts, that the government can reasonably restrict your liberties for the common good. Congratulations. Is that the linchpin that anything's going to turn on? And I might want to add that the UC Berkeley dean, professor at law, cited a case that was on quarantining fruits and vegetables to prevent the spread of an alfalfa weevil, which is an entirely different kind of quarantine than a stay-at-home order. Now, I'm not saying that he's a bad professor or that he's a bad attorney, but I am just suggesting to you that he is not dealing expressly with the stay-at-home order, because fruits and vegetables aren't being told to stay at home. And no, that was not a slander against disabled persons. So my point is that I'm not trying to bash on Blue Bacon at this point. You know, he doesn't understand when he's wrong. This isn't the level of intercourse that is going to educate him. I just want to point out that once again, this shows the difference between the way an attorney thinks and the way a cop thinks. And there's a reason why cops don't make decisions on what is or isn't constitutional. Attorneys don't either unless they're judges, in which case they do. So anyway, that's about it for today. I hope everybody has a great weekend. Thank you for watching. And I'll put links to screenshots of those two comments from Blue Bacon in the description if I remember. Thanks for watching. Have a great day.